just keep it going. I just want to explain why I put literary work and why the user interfaces and all your video work, because that is important for something about them. And then technical drawings are another kind of goes along with software. Now I think these things are unique, because the whole point of copyright is you're not supposed to overprotect anything that is functional with copyright. Copyright, that is what design patents are for. You're not supposed to be able to copyright a useful article with copyright. I've read the cases, I understand what they were saying, I don't understand how they got there, that all of these things are copyrightable because they are ultimately very functional. But that's the way they decided to do it. So technical drawings, again, is about copy. If I have technical drawings on my desk, and you come in and you take those technical drawings and you either steal them and or copy them, then you have infringed my copyright. If you come into my office with all the stuff you need, and you look at my technical drawings, and you build the thing that my technical drawings are for, you have not committed copyright infringement, because you didn't copy them. So they protect those plans, that piece of paper that has technical drawings on it. That's what that protects. There is an exception with architectural works, but that was a very special statute that they wrote, that there are two copyrights. There are copyrights in the blueprints, and then there are copyrights in the elevation. But for everything else, it's a technical drawing. Yeah, there's a limited copyright there, but it's only in the plan. So we have the derivative works, and this kind of goes to the whole why software is important, because you might want to change it. So a derivative work is something where it's kind of like the patent equivalent of improving something. You either improve it, you bring it, you invent it, you write the free code or something. That is called derivative work, and that right is exclusive to the person who wrote the original work. So that's important mostly for software. Because when you go to the developer and he gives you that stuff, even if he gives you the code or whatever, if you want to change it, right, that's a derivative work. That we use with a compilation, which this is important if you're going to have a website where you let other people post on your website. Is there anybody who's going to have that, any kind of interactive webpage like that for their business, where other people are posting on your webpage? That's a really dangerous place to be. You know, but, I mean, if you speak with an attorney when you're developing webpages, there are ways to insulate it. But you can get into a lot of trouble because somebody else posted copyrighted material on your webpage if you don't do the right things. And there are a lot of webpages, they exist for other people to upload content. So what, I mean, the Digital Land Copyright Act and the Safe Harbor provisions, that's a whole other lecture. But there are things you can do that will insulate you. You just have to have policies in place that in case somebody says, hey, that's my copyright stuff, there are things you have to do, and if you do them, you won't be sued for trademark, for copyright.
But what about a staff person? What if I have a program on my team that works for my company? I mean,
well, yeah, that's different than having people upload stuff. So you know, Facebook has a policy. You know, you think someone stole your copyrightable stuff and put it on Facebook. Facebook has a policy. So you know, any of these social media sites, or if it's just even if you're trying to create a knowledge center for your area, where you're trying to invite experts to come in and chime in on whatever news is, you know, that you run into danger, because if you don't follow the right rules, you get sued for copyright. The other thing about compilation is, I don't know if this is handy or put out there. I can take the 10 best Christmas movies, what I think are the best 10 Christmas movies ever made, put them together in a package, and sell it. And that, I have a copyright in that compilation. I have decided, I have set the criteria in my head, I have used artistic judgment You figure out which ones are the 10 best, and so I have a copyright in that compilation. I'm responsible to whoever owns the copyrights to each one of those movies for money, but I have my own copyright in the compilation. So there are scenarios where that can actually become a protectable asset for a lot of businesses. And we'll talk about this with you guys later, but you guys should be following copyrights all the time. Every piece of jewelry you create is its own copyright. And it's just something that can be a tremendous value, particularly if you're trying to build a corporate asset. There are different things you can do with all these things. You can preclude somebody else from actually competing with you, or you can build corporate assets so that when Google comes, write a check. They'll write a bigger check because you have all these wonderful assets that they're acquiring. Google loves buying these local products. But now we have the ownership.
So you don't get any, like, if I take a bunch of different clips of a movie that people are on YouTube and then make a compilation of it, you can copyright that?
Yep. That doesn't mean that the people whose clips you took can't stop you unless you have a license to use the clips. But you do have a copyright in that fixed product, that combination. Ownership. This, the only reason I didn't want to go off on tangent, I just said it's too important not to give it all the attention it's due. This is critical, and this falls squarely under the human capital part of that slide in the beginning. Assuming you're not going to be working all by yourself, human capital is something you should pay the most attention to. The people with whom you will be working, are they your employees or are they contractors? And what you want them to be and what they want to be has absolutely no legal significance whatsoever. Do you pay them a wage? Do you withhold their taxes? Do you say, listen, you got to be at work between 9 and 5? And then obviously all these, fairly standard act rules apply to you. You have to do workman's comp and all these other things. Are they a FICA employee? If the FICA man shows up, that's good evidence that they are an employee. Or are they a contractor? Will you pay them based on performance? Do they have a lot of discretion in what they're going to do? Can they work wherever they want? Can they, so for example, if you go to somebody and say, I want this website. Not every day I want the website. Bring it back to me. I don't care how you do it. You can go hire all the other people you want to help you do it. You can sub it out, just make it what you want. That's a contract. Well, you generally don't have that kind of authority. Generally tell the employee how you want it done in the manner. That's important because if they are employees and they are working within the scope of their employment, anything they create from a copyright standpoint will belong to the employer. It's not a transfer of rights. The employer actually owns it from the moment of creation. If they are a contractor, the opposite. If they are a contractor, when they create that thing, it's theirs, they own it. You have a license to use it. It's an implied, it could either be an implied or a written license. But obviously if I pay you to develop software for me, I have the right to use the software. As long as I pay for it.
What if you make them sign a non-compete?
Well, non-compete doesn't affect copyright ownership. If they are a contractor, you want them to sign a work for hire. Preferably before work starts. Of course, we're split about when it has to be signed, but preferably before work starts. And what a work for hire is there's a bunch of requirements. First of all, you have to go to the person and ask for it specifically. And it has to be one of, there's a list of 9 things that can be works for hire. Audiovisual works are one of them. Literary works are not. That's why the source sort of doesn't qualify. But the user interface does. But it has to be in writing and it has to be signed. Now, there are agreements in the legal world that nobody wrote anything down and nobody signed anything, but there was an agreement, and then we can go to court. We can fight about what people say and all these other things, and the court will find, yes, there was an agreement, there was a contract there. not if, there has to be, it's not a written document, you do not have a work for hire, and all the copyrights, all the intellectual property will remain with the contractor, who can now go sell to the competition if he wants to. So in your agreement, you want to have established it as a work for hire, and to the extent that it may not qualify as a work for hire, you want an assignment. An assignment is, I have rights, I'm giving them to you in exchange for money. But again, all transfer, that has to be written and signed. The employee, again, the employee, the fact that the employer, that isn't a transfer, the employer is the owner from the beginning, and the reason that's important is because without that, with any transfer, it has to be written and signed. So if he's an employee, a lot of times they're not going to be a written and signed agreement for everything they come up with.
Are you talking from an employee standpoint or an owner standpoint?
The employer, so for example, when you fill out the copyright application, it will ask you who is the author, and then it will also ask you who is claiming ownership, because they may be different. If you work for him, if you wait 9 to 5, you come in to write. When you fill out that copyright application, he is the claimant and he is the author, or the business is. Now, if you're a contractor, and we're assuming that there has been a transfer of the rights when we fill the copyright application, you are the author. His business is the claimant. They're the ones that are saying they own it by virtue of this agreement that we're submitting along this application. You are in the industry that creates more litigation, at least on the state level, than anything else I've ever seen in this area, because it goes in on the web developer, lock down your web developer, because they have the keys to the kingdom. You're in an industry now where if you make your web developer mad, he can shut your business down in 15 minutes. So,
I always try to retain that key. But the thing is,
don't let them retain that key. Sorry.
what is the, okay, so like, for example, I'm getting into kind of like a partnership with an e-commerce company. They already have a website, existing website, and I'm going in and I'm going to make it better for performance percentage, yet I want to own that. So does he have to sign anything, or is it his obligation to present me with something?
In the absence of anything else, you're going to own it. Because it doesn't sound, because there's a performance factor in it, it doesn't sound like you're an employee. I mean, I guess you could be. There are kind of the facts are. But if you are not an employee and they don't do anything to the contrary, you're going to. Yeah, it has to be. You can't just be. For example, in the case went on where they're trying to say there was a contract in fact. But they sent them the contract and he sent back an email and said, yeah, okay. You know, he didn't sign the contract, he just said, yeah, okay. Right? And that's the kind of stuff we'll look at it and go, all right, there was an agreement. If they send you a work for hire and you send them back an email that says, yeah, okay, not that has to be, this is going through that, where it has to be written signed. I will tell you this, that I would not do that if I were them. If they're savvy, why would they pay you percentages and performances and basically premium if they're really not going to own anything? So be careful about that.
Can I just paraphrase real quick? So if I hire what's your name again? Brandon. If I hire Brandon.
Don't hire Brandon, he likes the whole thing.
I know that. I get that now. But let's just say the nice Brandon.
Okay.
He had selfish
I've
Brandon.
never shut down anyone's site.
Okay, let's say I hire Brandon and say, listen, here's product idea, here's a vision doc, the whole, scope, all the development stuff. I just need you to code, and guess what? Wherever you code, source plus object, it's mine. It's my company's. The work for hire clause or legalese takes care of that?
No.
Okay.
You hire me as an example. Right?
Contractor, not a
Contract, yes, they need this.
So work for hire.
No, the work for hire is probably not going to be enough.
Okay, right, okay.
Because the source code is not one of the statutory.
So it's got to be blatant in the contract.
Can you blame the contract? You want the contract to say,
My source.
to the extent that the stuff you'll do for me is protectable as a work for hire, it is. And for everything else you do that isn't, you are assigning it to me right now. Even though we have people who will assign it to me right now. And there will also be contractual obligations that you will sign in the future all the documents that I need to get this stuff on.
I mean, I'm surprised that's not prevalent because, I mean, a lot of the competitive advantage, especially in, some industries that just a little bit of better algorithms, a little bit of smarter way of searching, organizing, storing data and presenting data, that people don't do more than that because the not nice brands in the world can run off to the competitors and say, hey, pay me $500,000 and I'll build this thing for you.
That's why the web guy, and I'm assuming he's not just making a pretty good page.
No, it's just more.
A true web developer is doing obviously much more hardcore programming, integrating databases and all this other stuff. Seriously, it's the nerve center. I mean, there's hardly any business there where that's not the nerve center. So you have all this stuff. The nerve center is all in the hands of a guy that really, if he's not an employee, where does his loyalty lie? And it's not just being nefarious or anything like that.
Right.
But disputes happen. That's why we have courts. And so if the dispute happens, the guy who has his finger on the pulse of your business, you're in an argument with him. And the thing is about the web developer, program development in general, it's not regulated. They can just turn it off. And then all you can do is take them to court and make them turn it back on. And there's hardly ever any damages attached to it or anything like that. Because normally these guys have they have all your registration data. A lot of times they're the ones who register the domain. So they have the password and everything. So it's not just turning off the programs. That's something else that goes into the intellectual assets, your domain registration information. Critical information there. Make sure you have that right. And then it gets even more complicated if you have more than one developer. Which, depending on the thing is, if you're going to have more than one developer, you're getting to that size of organization, they are more likely to become employees. But the overwhelming majority of software development that gets done out there is done by brands or contractors. They're not employees.
So tell me, we get both work for hire, or is it just going to be a copyright assignment after the fact?
Both.
One of both. Just to cover your bases.
Yep. Cool. It's called bootstrapping, but you want both. When I was a bartender for Disney World after college. I got a molecular biology degree, and there was nothing else to do except for go be a bartender at Disney World. Sorry?
Is you already used yet?
Yes. As a bartender for Disney World, I signed the most encompassing document I ever. My mortgage didn't cover as many things as the thing. I promised them that pretty much any idea that I had for anything was going to be there. I'm pretty sure they have some kind of rights to my children. I think I honestly found them everything in perpetuity, everything I've ever created. But that was in there because, again, this is going into your scope. You hire him. His employee program. So that's anything he does is in his scope. You hire him to manage day-to-day affairs. But he's a really good programmer. So he programs on the side and creates a thing. Is that within the scope of his employment? Okay. So that's going to be like that. It's going to be a case-by-case determination. So all these things become very important in your contracts. Industry of copyrights, this is going to end if it's done by an individual. It's 70 years after the individual dies. If it's a corporation, it's 95 years from publication or 120 years. And if it's a work for hire, it's included as a corporate. It's included as a corporate work. So these things last a long time. So they are valuable rights. One thing is important that if you're hiring people, again, so that individual thing is very important. So even though, you guys hire a jewelry designer, right? Which hire to design jewelry for you. That's going to be Sparkle, is the owner. So it's going to be a corporate book. And that's important for 2 years, not only for 2 reasons, not only does it last longer, there's a right of revision in copyrights. If I'm an individual, I come up with something copyrightable and license it to edit here. Again, I transfer it, not just the license, I transfer it from, gives me money and I sell it. When I die, even though there's 7 years left on it, whoever gets it after I die, whoever those rights would have passed to, they can say I want it back. It's a ridiculous fact of copyright law they put in there because we're dealing in, this is the more emotional side of things, and they can actually have a termination of rights. So you don't want it to be an individual who creates it. You want it to be a corporation who creates it because corporations don't have that right of termination. After the registration, do it. Register. You're now registered. It's $45 to do it online. Have an attorney do 1 or 2 of them for you. Just to kind of show you how the forms get done. And then after that, it's just kind of changing the words around the form and do it for $45. Because first of all, you can't sue anybody for trademark, for copyright infringement until you at least have an application going. It gives you a whole bunch of advantages. So one of the worst things in a copyright litigation is that after you've proven that someone ripped you off and copied your stuff, now you have to go to the damages. It's a whole other trial, basically. Trying to figure out how much they owe you, if they owe you actual damages. If you registered before they infringed, or within 3 months of when you created it, you can get statutory damage. And you can tell the court will say, you're just bad, and we're going to make up a number, and you're going to have to pay. And then you can also get attorneys. So for $45, why you wouldn't do that if you are in an industry where you are creating copyrightable subject matter? Why you would rely on your common law rights and then file afterwards for $45 is just beyond me.
But that is if you have a product?
Well, it depends. Anything is copyrightable. So, for example, you said you're in biotech. What are you producing?
Well, we're doing drug discovery, but we're also doing virtual work. So the reason I came on, we're creating libraries of small molecules virtually.
Okay.
That might be copyrightable.
To a certain degree, it is. The facts aren't copyrightable. So, for example, again, like the phone book, in which case the phone book isn't copyrightable. But everybody knows what a phone book is, right? What is it? Just making sure. Yeah. It's called sentences. I don't know why. I think it's that. But the phone book, as it's written, is not copyrightable. It's just pure data. There's nothing creative about it. It's purely functional. You could create a phone book that was copyrighted. If you could create a phone book where instead of being listed alphabetically, everybody was listed by these are all the people whose names rhyme with this fruit. And then, that's one way to organize it. That would be copyrightable because there's absolutely no function to that whatsoever. But if it's pure data, where you're not making any kind of decisions, you're just aggregating the data, there's really no copyright there, or very thin copyright. But if you are collecting specific small molecules, and you're deciding what goes into this library, then your copyright liability tends to increase. Now, is that your actual product? Is it the library?
No, we want to find drug compounds we can patent as drugs. But in the process, we're creating these virtual libraries of small molecules, drug-like molecules, and we're being selective. And then we're going to screen those against the protein to find something we can patent.
There's finish copyright there. But there's also, I'll show you this when we get the trade secrets, how you can, trade secrets might be better for you, but they're not mutually exclusive. So here's pop quiz. Everybody knows what that is? Okay. But do you know, that's Steamboat Willie? Yeah, Steamboat Willie. That was it was the first Mickey Mouse cartoon. I love this because I got the partner disagreement about this. This was back when they were fighting over the extension. They recently extended the term of the copyright. But it was a big deal because Steamboat Willie was about to come on copyright. And he was talking about, oh, Disney's going to lose their copyright and Mickey Mouse. And that was crazy. Disney is not going to let that happen. So yes, there is a copyright in Mickey Mouse. There is a copyright in the movie Steamboat Willie. But when was the last time somebody saw a Disney animated film? Not a Pixar or something like that, a Disney animated film. And I told them this is what they were going to do, by the way, and I was right. And that's why it tickles me. When you go to see a Disney animated film, at the beginning, this will pop up. And it will actually, it's a little bit of a movie. It's just a, I think, a little 10-second segment of this thing from Steamboat Willie. And then afterwards it says Disney Animation Studios. They have transferred that copyright to trademark, which will not expire. So, it's like, oh, Steamboat Willie's coming, we're going to start selling Steamboat Willie stuff. It's going to be great, we're going to get lots of money off it. Well, first of all, nobody wants to buy Steamboat Willie stuff. But if I sell you a mug, let's say it's a mug where it looks like that, that's the handle, right? Mickey doing that. And it's attached to a mug. I sell that. Who do you think made that mug? You think Disney made it? Yeah, you're finding the copyright in front of you. think Disney made it. And that's what trademarks are. What does this make people, where do people think this came from based on this? That's what it is. So there is copyright in there, there's trademark in there, and there's actually some patents involved in it, but that was in the way they made it. Disney actually didn't just make cool stuff. He really did innovate the technology and make it